Hello, and welcome to today's Government Structure Committee meeting of the Los Angeles Harbor Commission. Today we will be talking about city attorney. I will begin by calling roll. The chair is present, Commissioner Fuentes,
President.
Commissioner Matz.
President.
We will first start by approving our meeting minutes from our last meeting. Do I have a motion for approval of minutes?
So moved.
Session. Great, that's approved. We're gonna actually do public comment at the end of the day today, because we have a few presenters who are virtual. This was noticed on our website earlier. So the next thing that we'll be talking about, is item number one, study session. Government structure, comment and discussion on issues related to the city attorney, evaluating the current structure and the structure of other cities, exploring reforms or roles, improve checks and balances, and strengthening accountability. I will now leave it to staff to administer this meeting.
Thank you, Mr. Chair. After a little bit of this, and commissioners, we're happy to get this started. We have, as you said, we have three virtual presentations from people who are out of town, including the Long Beach City prosecutor who's actually out of the time zone today. Currently, so we're gonna get started with the New York City Council Division of Legislative Council in drafting. We have Wesley Jones and Jeffrey Baker of the Jones version will be here in two shapes. Second, we're going to let them get their technology up and running.
Okay, can you hear us?
Can you hear us?
We can hear you.
Okay, we're gonna just situate our microphone correctly and turn up all the volume and simply the room can hear you. Can you test your microphones again?
Testing, can you hear?
It's perfect. Thank you so much.
Thank you. Should I share my screen, the slides?
Absolutely.
Okay, is that working?
Yes, we can see you. And the section.
Okay, thank you. So to begin, we'll have a very brief outline of the structure of the New York City Council. It is going to include a couple of divisions that we do not have direct supervision over. So this is going to be somewhat of a high-level gloss, but we are happy to try to answer any questions that you have to the best of our ability. So first, I just wanted to introduce myself. I'm Jeffrey Baker. I am the Deputy Chief of Staff for Legislation and Policy at the City Council, New York City Council. I've been at the council for nearly 20 years now. I've spent the entirety of my career at the council within the legislative division. I've served in pretty much every role that we have had at the council for attorneys in the legislative division, working my way up to my current position. And then I'll turn it over to my colleague, Wes.
Hello, my name is Wesley Jones. I'm a Deputy Director in the Legislative Division. I currently oversee the Legislative Council and Drafting Division within the Legislative Division. And I have worked for the City Council since 2013 with a stint at the New York City Law Department in their Legal Counsel Division.
Okay. So the first thing we'll discuss is just generally speaking, the government of the city of New York. The city has two major parts to it. We have the mayor's office, the executive, and we have the legislative branch, which is represented in most cases by the New York City Council. The structure of the New York City government is a creature of state law enactment. So there's a number of enactments that we have to conform to. The Charter of New York City was initially created by the state. The state occasionally will amend or update our charter. We do also internally have some charter making authority, but the state retains that authority as well. And so the powers that the city has is highly dependent on state law. We are a home rule state, which means the state has generally granted some authority to local municipalities to control their own operations, but I think sort of a unique quirk to New York state law is that there are a number of outs that the state has constructed to allow it to continue to have policy making authority over the city or over any city if it chooses to exercise that authority. So we find ourselves in the legislative body here very much constrained by state law enactments. As I said, the council is the legislative body of the city, the mayor is the executive. How we enact our laws, the mayor does have the veto authority. So we'll get into a little bit later how we approach passing legislation. But we do approach it generally as we are partners with the executive in creating policy, including our local laws. We do seek their advice on every bill that we pass because ultimately they're going to be the ones that are effectuating it. So it's good to have that on the ground experience informing our legislation. But that doesn't mean that we're always on the same page, and we will sometimes enact things that they disagree with. The mayor does have veto authority, and the council does have the power to override that. Again, we'll speak to that a little bit later. Excuse me. So the city council's responsibilities are to enact local laws. We also approve the city's budget. We approve land use applications and zoning changes. The council has general oversight of city agencies, and also individual council members act as a liaison between their local communities and city agencies. I'll get to that in a little bit. So the last major reform of the city council happened in 1988. At that time, there was a prior to that time, there was a superior legislative body that existed in New York City. But that body, which was found to be an unconstitutional violation of one person, one vote, it was ultimately deemed unconstitutional, and the city council became the only, for most purposes, legislative body in the city. At that time, the city council did gain the powers of land use applications. Prior to that, we did not have it. The council did, prior to that, have some local law ability, but the other legislative body of the city did also have some authority in that respect. So this, the current constitution of the New York City Council, it finally took effect in 1989, but it is a relatively recent development in New York City history. So now I'll speak about the structure of the New York City Council. So our council has 51 members. That's in our charter. It establishes how many members we have. Each member represents approximately 172,000 persons. There is, obviously, as we're setting out our districts, there is some variation there. They're reapportioned every 10 years, and council members will run on the new districts when they are reapportioned. The terms of council members are 4-year terms. They are term limited after 2 consecutive terms. Term limits is also a relatively recent development in the city council. We did briefly experiment with raising it to 3 terms, but by a referendum at popular election, that was reduced back down to 2 terms. A member who sits out 1 election cycle can run for council again and can serve another 2 consecutive terms. So there's not a lifetime ban on service at the council. It's just a ban on consecutive service at the council. From the members, the body will choose a speaker. The speaker is the leader of the body and will be responsible for setting the body's agenda and leading on negotiations, including land use and budget making powers, also setting the legislative agenda. Other leadership roles include majority and minority leaders. We do have, I think it's currently 6 Republicans out of the 51 members. The rest are Democrats. That does actually represent a high point number in recent years. Our number of Republican members was 2, I think 10 years ago. It is growing and may continue to grow. We also divide up the body into a number of different structures in order to do some of the work of the council. That includes committee chairs. So some members are assigned committees to oversee. We also have caucus chairs. There are different caucuses. The members have the right to organize themselves any way they see fit. We have 2 political caucuses, obviously the Democrat and Republican caucuses, but we also have Women's Caucus, we have Irish Caucus, we have a Common Sense Caucus, we have a Progressive Caucus. When members get together and want to create a caucus, they petition the leadership of the council to get it approved and recognized, and then they can hold their meetings as caucus members and try to set agenda priority items for the body, for them to then advocate that the body take on. We also have a Black, Latino, Asian caucus, an LGBTQ caucus, and numerous others. Finally, we have delegation chairs. So New York City, sort of uniquely, I believe, in the United States, is also divided into boroughs, which are also counties under the city, under state government structure. So each one of those boroughs will have a number of council members whose districts reside within those counties or boroughs, and they also will band together as a delegation. That is very important during our budgetary process because certain allocations are allocated on a borough-wide basis, as opposed to there's citywide appropriations, there's borough-wide appropriations, and there are committee, council member district appropriations as well. So there's all of these different levels of appropriations that are made. So the delegation chairs are very important during the budget process. Next, we'll discuss committees. So the committee is the basic level of organization at the council for getting the work of the council done. As I mentioned, each committee has a chair. We currently have 34 standing committees and 4 subcommittees and 1 task force. So if you add all that up, that means we have 39 out of our 51 members are a chair or a leader of a standing committee, a subcommittee, or a task force. So items are assigned to those committees for work. That includes legislation, bills. When a bill is introduced, it will be assigned to a committee. The Finance Committee will handle the budgetary items of the council. The Land Use Committee and its subcommittees will handle the land use responsibilities of the council. All of the committees, including land use and finance, have oversight authority as well. So each one in our rules has been designated certain city agencies over which it has oversight. And each committee can hold public hearings on oversight matters with respect to those agencies. And additionally can hold hearings with respect to legislation that is before it. So public hearings to solicit input on legislation. So the responsibilities of the committees are to review and amend proposed legislation, to hold public hearings on agency oversight, to report items from committee for consideration of the council. So the council will not consider an item unless the committee has reported it to the full council. So that makes the committee work, again, it's the fundamental building block of all the work that the city council does is in committees. So they'll hold the oversight hearings, or they'll hold a hearing on legislation. They will consider it, they may amend it, they may reject it, and ultimately they may pass it on, report it to the full council for consideration by the entire body. The Committee on Finance, as I mentioned, also does the budget responsibilities, and land use does the land use items. So now I'll speak about something we know a little bit more about, which is the land use division, or excuse me, the legislative division. So we have in our legislative division, the council is divided into we have the legislative division. We handle the bulk of the committee work. There's also a finance division, which handles the finance committee and subcommittees. And we have a land use division, which handles the land use committee and the land use subcommittee. So anything that doesn't, and then we also have an OG, the general counsel, which handles a rules committee and a standards and ethics committee. So aside from those, the legislative division will handle all of the other committees. And the bulk of the bill drafting, bill negotiation, and bill passage responsibilities as well. So I'm just going to quickly run through some of the responsibilities, and I'm going to turn over to Wes to talk a little bit more about how we approach bill drafting. So obviously, one of our big responsibilities is to draft legislation, but we also will conduct legal and policy research. We prepare committee hearings. So anytime a chair wants to hold a hearing on an agency or a policy that they're implementing, the committee will do the research on it, including talking to stakeholders, and preparing a briefing document. We will write opening statements for the chairs. We will draft questions. We will do follow-up after the hearing to make sure that we have gotten the answers that the council members have asked for. We also advise the council members and the speaker on legal and policy issues related to legislation and related to agency actions. Occasionally, our staff will be asked to attend meetings on behalf of the body. So if there's an agency that is conducting a public meeting, we may attend either to provide our own testimony in rare occasions or just to observe and make sure that we understand what's happening. And finally, we will negotiate the legislation. And I'll talk a little bit more about that later. But first, I want to turn it over to Wes, who's going to describe how we approach bill drafting.
Thanks, Jeff. So as Jeff said, the legislative division is part of the central staff at the council, and we provide legislative drafting services to all of the members and the public advocate on an equitable, timely, and confidential basis. So this means that we draft for members of minority parties as well as the majority party. We strive to return final bills within 60 days of a drafting request as practicable. And we do not share information about one member's requests with another member or with the public without their permission. As far as the workflow goes, members will submit their drafting requests using a computer software program developed in-house. And from there, requests for local laws or bills will be assigned to an attorney. And in most cases, non-binding resolutions will be assigned to policy analysts who typically are not attorneys for further research and drafting. So once the request is assigned, the assigned drafter will conduct legal and policy research, usually on topics related to constitutional issues, especially the Supremacy Clause, also looking at preemption by federal or state statutes or regulations, and looking at our own internal New York City separation of powers doctrine to see if there are additional procedural requirements that the bill would have to go through in order to be adopted. Once the research is conducted, we'll provide advice to the sponsor of the legislation, along with ideally a draft of the bill. And then it's at their option whether they would like to introduce the bill or not. Up to this point, unless the sponsor of the legislation is comfortable with it, typically this is a non-public process, and the bill only becomes public for the first time when it's introduced to the full council and referred to committee. So I'll give it back to Jeff to talk a little bit more about the process from there.
So from there, once the bill has been introduced, that is, as Wes said, that's the first time that a bill becomes public. From that moment, we will frequently get solicitation by interested stakeholders who want to meet about the bill. As Wes described the process, since we don't engage with outside stakeholders prior to a bill being introduced, without the permission of the prime sponsor, we are often drafting in a vacuum. So we do have a lot of experience in our legislative drafting, our legislative council and drafting division, but we don't obviously know everything. And so we're drafting in a bit of a vacuum. So this is the first time that we really have an opportunity to hear from the public and get some real world experience in our legislation. So it's a very important part of the process. Before we pass any bill, we will have a public hearing on it. Our public hearings on legislation are open. We have a sign up process where people can sign up to testify on a bill, but we also allow people to just drop in on a hearing. We also have, our hearings are hybrid. We allow people to access it by Zoom. We have in-person hearing locations, so people can either come in person or they can log in on Zoom. They can do that day of while the proceeding is happening, and they can sign up to speak. We will, and then we also keep the record open for 3 days after a hearing. So if a person wants to correct the record, they may have misstated something, or they want to supplement the testimony that they gave at the hearing, they will have 3 days to do so. After the 3 days, we are still actively engaging with stakeholders on the legislative process. Most of the persons who will come in and testify, we will continue to reach out as we are amending the bill to see if they have any additional feedback. We do try to be a collaborative body in that respect. That doesn't mean that we're going to take everybody's feedback. A lot of times we have people who are, adverse to the legislation entirely. Where we can do something that still achieves the goals of the council or achieves the goals of the sponsor, we will try to accommodate them as best we can, but there are obviously some times when that's just not possible. The final say on all the bills is the prime sponsor. On what the bill will say or do is the prime sponsor. That's who has the final sign off. Once we have negotiated a bill into what we believe is its final form, we have a state law requirement that we have to put that on the desks in its final form, basically 8 days before we vote on it by the full council. That's to give council members the time to be adequately review the legislation, so they understand it, they can ask questions on it. We also, prior to aging any bill, we will caucus with the Democratic members. We will present the bill to them and allow them to ask questions or make suggestions. And we frequently do amend bills based on comments at our caucus. Finally, once it is in its final form and it's been aged, the committee will report it. If they approve of it by a majority vote, it will be reported to the full council. The full council meets 2 times every month, with the exception of July and August, in which they meet only once per month during the summer months. At that meeting of the entire body, anything that has been reported by committees since the last stated meeting will then be on the agenda for the full body, and the full body will then be able to vote on each of those items. If an item passes, we do require a majority of the entire body. So that's 26 members. That's regardless of any quorum in the room. We need a quorum in order to proceed, but we need 26 yes votes in order to pass. Once it passes, it's then submitted to the mayor. The mayor has 30 days to either sign it, in which case it will become law, to not sign it, to do nothing. And if the mayor takes no action at all after 30 days, it will also become law. There is no pocket veto in New York City. Or the mayor can veto it. So mayor vetoes it, he will return it to the body with a statement outlining the reasons why he or she vetoed it. At that point, the council will officially receive it at its next official stated meeting, and will have 30 days from that meeting to override a veto. That override requires a supermajority of 2/3 of the body, or 34 members. If the council takes no action or fails to override it, it will not become law. If we do override it, then the law becomes effective as of the override. Okay. Next, I'll just go through a couple of we were asked to present on a couple of other things. So next is Office of General Counsel. So Our Office of General Counsel is separate from the Legislative Division. It provides legal advice to members about contracted services. So each member has district offices in addition to offices at a building that is adjacent to City Hall. So when they're doing work at City Hall, they have an office space available to them, but most of their work is done in their own districts. So each of them is required, well, not required, but each of them, as a matter of practice, has a district office. So finding that office and signing a lease for that is the General Counsel's office will assist with them. Also procuring any additional services that they may need out of that office. The council also advises on their ethical obligations as elected officers, including actions that there are certain things that can or can't be done around elections due to their status as elected officers. And the General Counsel's office will also represent or will assist in the representation of members or the council where the members are acting in their official capacity, or the council if there's lawsuits. So if the council is initiating a lawsuit against an agency, for example, to implement a law, or if somebody is suing or claiming that law has no effect, then the General Counsel's office gets involved in that defense. General Counsel's office also acts as a parliamentarian for the body. It keeps the rules up to date, and will sit next to our majority leader, who is the presiding officer at our stated meetings, and will advise on procedure during those meetings. We also liaise with our General Counsel's office quite regularly on bills that we think may have some litigation risk. Because of their role in defending litigation, they are much more well-versed on litigation, and so they help us assess litigation risk and help us amend laws to avoid litigation risk if possible. They also have the Committee on Standards and Ethics, which they're responsible for investigating ethical complaints involving council members. Those meetings are usually held in executive session and usually private. Ultimately, when they reach their findings, that would be public, and they would take a vote on their findings. And historically, there's been some activity there, but it's actually been relatively quiet in the last couple of years, which is a good thing. Next, we have the Finance Division and the budget process. So again, a very quick gloss of this. So the City Council budget exceeds $110 billion. The key stages of the budgetary process is the preliminary budget, which starts in February. We actually I think we start getting the preliminary, the mayor's office will send over a preliminary budget late January, early February. The City Council will start holding hearings on the preliminary budget in March. The executive budget then comes out in April, and the council will hold hearings on the executive budget in April. And then finally, the budget will be negotiated. There is a budget negotiation team made up of selected council members who will negotiate line items in the budget. And when they finally reach the final budget, there's a handshake. We are obligated as a city to have a balanced budget. And we also have a somewhat medium hard deadline of July 1st for getting the budget done. If we don't get the budget done, there are some, people might not get paid on time, and there's other actions that may need to be taken. But we so far have, not in recent history, have gone over that deadline. So we've always been able to get things done on time so far. The Finance Division also provides economic and fiscal analysis and makes recommendations on those. So anytime we pass a bill, we are required to have a fiscal impact statement. That's what the impact to the city would be for that bill if it were to pass. The Mayor's Office of Management and Budget also recently, due to a charter change, also has the ability to produce its own fiscal impact statement. Because occasionally the mayor's office disagrees with us on what the fiscal impact would be. So every bill that we pass has to have at least one produced by the council, and possibly two, with the second one being produced by the mayor's office on the fiscal impact of what that legislation would be. Then we have constituent services. So as I mentioned, every member has their own district offices. They serve 172,000 constituents on average. One of the biggest jobs and maybe most time-consuming jobs of council members is to act as a liaison between all of the various city agencies and their constituents. New York City is a giant bureaucracy. The agencies are huge. Some of them have tens of thousands of employees. And navigating the system can be very complicated, particularly in a city as with a lot of different spoken languages, a lot of different cultures, a lot of migrants in the city. So the council members act within their communities as an ombudsperson for their constituents to try to help get them services where they're struggling. They also work with local organizations, their CBOs, to help people find housing and other benefits or to deal with other quality of life issues. And frequently, even outside of legislation, council members are advocating with agencies to get, park upgrades or a speed bump near a school, other infrastructure upgrades that are supposed to occur on a timely basis, just to make sure that these things are happening. Having new trees installed along a street. So these are sort of the bread and butter of what a lot of council members do. So that's our presentation. That's the city council in a nutshell. But now we're open to answering any of your questions.
Great, thank you so much for that presentation. We really appreciate how thorough you are with what city council in the city of New York. We will begin with a few questions, and the chair recognizes Commissioner Mack.
Thank you for your presentation and overall just the rundown of New York City government infrastructure. I had a couple of questions. I'll start with one and it kind of has to do with commissioners. Wanted to check sound check. Can you hear us okay?
Yes.
Okay, perfect. First question is overall, was wondering if you can share more about kind of the checks and balances across the different kind of roles within city government. So just to name them, the borough presidents, the council members, mayors, and the comptroller. And more specifically, I am interested in hearing more about the interactions between borough presidents and the city council members. At least with us within this committee, we've been exploring a similar model of regional and council members, and so wanted to hear more of your thoughts on that.
Yeah, so the city does have, as you mentioned, a number of other citywide elected offices. We have the public advocate and we have the comptroller. We also have, each borough has its own borough president. These are somewhat relics of prior the way the city had organized itself previously. So some of them have some residual power. The public advocate used to be a position that was, I believe, the president of the council. And it eventually, when we did our charter change in 1989, it got split off into its own thing. And the speaker of the council became a new office and internal to the body itself and not a separate elected official. The public advocate now has responsibility for the entire city, not just any particular borough, but for the entire city, of ensuring that the city agencies are working on behalf of the people. And so different public advocates have taken a different approach to that. Some of them have been very litigious against agencies. Some of them have tried to work more proactively with agencies. There's a lot of different ways, to approach this problem. One of our former public advocates went on to become our Attorney General of New York State. So there's a lot of experience, and one became mayor of the city. So there's a lot of experience that is in the public advocate's office, but the office itself is more of a it doesn't have a lot of institutional power. It's supposed to try to hold agencies accountable. The borough presidents do have some regional power within their boroughs, but largely their role in in the charter is around land use. They do have an advisory role during land use projects. So the mayor's Office of City Planning is mostly where land use projects get initiated. There's a community board and a borough-based hearing process that they have to go through before that can advance to the city council. Those opinions of the community board and the borough board are advisory, so the city planning commission does not have to take their findings into account, although I think they frequently do, before it advances to the city council for a final approval. The borough presidents are also responsible for impaneling the community boards. So they will appoint the members on each of the community boards. And again, those community boards do have a role in land use items, an advisory role in land use items, but they also, the community boards liaise with agencies. Many agencies are broken up into service districts, and those service districts will coincide with one or more community boards, and so they work directly with community boards in providing their services.
Thank you. We are nearing time, so I'll keep my question limited and then go back to Commissioner Matt for round two. Just so that you're aware, we're here today particularly to talk about potential reforms to the city attorney's office. In 1933, we had a city prosecutor whose office was dissolved, and the city attorney absorbed all of those responsibilities. So that's where our current structure comes from. But we're really looking at potential segmentation of that role today, which is what you have in the city of New York. Can you talk a little bit more about the interaction that your office has not just with the Office of General Counsel, but also with city DAs, because one of the main reforms we're looking at is bisecting the city attorney into a city prosecutor who would do prosecution, and then city attorney who would represent the mayor and council. So similar to what you have, so how does that relationship look like with your office, the general counsel and the DAs?
Yeah, I mean, I'll start, and I think Wes, you can talk a little bit more about our interaction with us and the law department on legislation. But we actually have a number of different entities that handle those functions. So we have district attorneys, which are actually, although they're paid out of the city coffer, they are state officers. They are locally elected, but they're pursuant to state law. They're the ones that will handle most, prosecution. We have separately from that, we have the law department. The law department is or corp counsel's office. They are the city's attorney. And so they will act as the city's attorney on behalf of any city agency, which would include the city council. And in the past, that's been a somewhat contentious relationship because where we may be in conflict with the mayor's office, they would frequently, side with the mayor's office in their opinions. In a recent charter revision, we made the appointment of the corp counsel pursuant to advice and consent of the city council. And since that has happened, I would say that the relationship between us and the corp counsel has become a lot more amicable. They will work with us. They will even bifurcate their office so that, part of their office will be talking to us and part will be talking to the mayor's office where that's possible on matters where we may be approaching it from different sides. We also internally to the council have our own general counsel's office, which will assist on litigation that is specifically with the city council. So corp counsel still will be lead on those, but our internal general counsel will assist them in briefing documents and others. And where there are cases where we are opposed to the city executive, our general counsels will represent us or will procure outside counsel to represent us. So Wes, did you want to talk just really quickly about how we liaise with the law department?
Sure. So in most cases, when we are preparing a bill, we will not actually interact with the law department in most cases, again, because of the confidentiality rules that we apply to council member requests. However, if the attorneys in our division think that there's a very thorny legal issue and it's a close case and we would like an additional opinion, we may get permission from the sponsor of the legislation to reach out to the law department to discuss. And typically in those cases, we'll be reaching out on a separate line of privilege. As Jeff mentioned, the law department will be interacting with us as a client, and if we ask them not to divulge information about the conversations with other agencies that they also represent, they will do that up to a certain point. And usually that point would be the point of introduction of the bill. And so that's typically the way it goes at the pre-introduction phase. And then once a bill is being it's been heard and it's being negotiated for final passage, the law department is typically going to be involved in the final negotiations of the bill as it moves towards passage. And in this case, they will be taking the position as the city's attorney, and they will be sort of working with the council in one way, and then also working with the agencies affected by the legislation in another way. And so it's all part of the larger negotiation of the bill.
Thank you. It seems like there are a lot of lawyers in the city of New York that do different things. Do you think that that's a benefit or is that a con?
You say a lot of attorneys?
A lot of attorneys who are doing, very different things, representing different clients throughout the city. Do you think that that's a benefit of the way that the city of New York is structured? Or are there a lot of problems that probably exist below the surface that we don't know about here?
I'll say that I think it's uncommon that there are legal issues with a piece of legislation that we're not aware of in some form or another by the time we pass a bill. I think that's the advantage of having a lot of different attorneys looking at legislation from a lot of different angles.
That's a really good answer. Thank you. I'll turn it over to Commissioner Fuentes for first questions.
Can you speak a little bit more to the feedback loop when legislation is being written? Specifically the inclusion of the public in that process? I know you covered it briefly.
Sure. So generally, when the legislation is being written, we are working directly with the sponsor who has requested the legislation. In some cases, they may prefer to bring in members of the public to these discussions. In some cases, they will have members of the public at the table with us talking about the legislation as it's being drafted. In other cases, they're working with us on one line and they are working with outside stakeholders separately. So they'll be talking with us, we'll provide them with advice, they'll decide how they want to proceed on that advice, and then they may relay that to an outside party or discuss the policy goals with them through a different lens based on our advice. We, in addition, will also be working with other parts of the city council. So Jeff mentioned that there's a very robust committee structure at the council. We will, in legislative council and drafting, we will work with the committee council, the committee policy analyst, the finance analyst, who are responsible for the subject matter area of the bill, to make sure that we are thinking of as many of the issues that may face the bill as we can in the short time that we are drafting the bill.
Thank you. And just to follow up, you had mentioned that council members will request in writing legislation, but it doesn't always move forward. Sometimes based off the writing, they want move it forward in the process. How often does that happen?
It happens often enough that I don't have a number in my head. That we send bills out to members. They may come back to us and ask for amendments based on further conversations. That may happen the day after, the week after, the year after. And in some cases, we'll never hear about the bill again. I don't have a solid figure in my head. Maybe Jeff, do you keep those statistics?
No, not exactly. I do think a lot of the conversation we have is around what the city's legislative authority is. As I started off the presentation, we are, we don't we have a lot of authority, but we don't have the same authority that the state does. And so we are constrained in many ways in what we are able to do. The council members are usually not themselves attorneys. They don't usually have an intimate understanding of what our legislative authority is. So they will make a request. That can be a quite reasonable policy request that as we go through the legislative research, we find we just don't have the authority to do, or not in the way they have requested it. And so when we come back to them and say, you know, we can't do it that way, we may be able to do it a different way, or maybe we can't do it at all, you know, sometimes they want to try to be very creative and keep pushing forward. And sometimes, as Wes said, you know, they just sort of walk away from the request.
Thank you.
Great. And Commissioner Matt will have the final estimate.
Yeah, just one more question, just because, New York has gone through city council expansion, it's about from 25 to 35 to now 51, and I was just curious if, from your knowledge on the top of your head, you can share what is the current language in the New York Charter around the council district, and if there's any, regarding kind of revisiting, size, or even just what does that expansion piece look like, if any?
I'm sorry, I think I missed part of the question.
Yeah, question is there any language in the New York Charter, New York City Charter that talks about city council district or size?
I was just gonna say, we can get that research for you, I just want the focus specifically on city attorneys.
Yeah.
Okay.
Great, well, thank you. We will just follow up later over email to get that information needed, but thank you so much for taking the time to speak with us today, all the way from New York. We really appreciate it.
Thanks for having us.
Pleasure.
Very much. Alrighty, we are gonna promote on Zoom our next presenter. Hopefully she's with us, New York City Comptroller, General Counsel, and Deputy Comptroller for Legal Affairs, Justina Rivera. Hold on, give us a second. Justina, are you there?
She's there. It just takes a second to promote to panelists.
One second.
Hello,
Hello, Justina.
Justina. Yes, Justina K. Rivera. Nice to meet you.
Well, Justin Ramirez here, say hello to Justina Rivera. Thank you for joining us, and thank you especially considering the time difference between our two hosts. But happy to let you kick off the presentation.
Okay, let me see if I can get this going without share my screen. Okay, can you see my screen?
Yes, we can.
Wonderful, wonderful. Okay, so I was here listening to my colleagues from the city council, and I'm going to make sure that I don't cover the things that they covered. I do have some of that also in my presentation because I thought it was helpful for you just to be situated with how we're set up in our structure, but I'm going to fast forward through a lot of that. What I will say by way of introduction, which you should know about me, you asked about city attorneys. I have been practicing for about 15 years, 12 of which have been on behalf of the city of New York. So I was an agency attorney, meaning I was an attorney situated inside one of the city agencies. I was a law department attorney, so the Office of the Corporation Counsel was an attorney situated at what is the equivalent of the law firm for the city of New York. And I am currently the general counsel of the Comptroller's Office, which, as they explained, the Comptroller is one of 3 citywide elected. So I'm an appointee of the current Comptroller, and I am a counsel to the office and to the Comptroller in his professional capacity. So I'll talk a little bit about that because I think it'll answer some of your questions about all the different attorneys and the interplay between all of those. Let's see. Okay, so I'm going to skip through this. We've already gone through the framework of the city. I just wanted to point out, though, unlike one of the things that you asked about was the public advocate's office and the controller's office. One thing I want to point out about the public advocate, well, while the power is really to be one of a mouthpiece, the public advocate is next in line in succession. If the mayor becomes unavailable, incapacitated, is no longer in office. So I think that's an important part of our government. And then the controller, unlike the public advocate, actually has some very concrete powers and duties that have some enforcement behind them. And I'll go through that so that you have an understanding of that. I'm going to go through that pretty quickly, and then I'm going to talk about the interplay between our office and the Corp Counsel, specifically as it relates to claims, because I know that's something that you were interested in. I'm going to just move through this. You have a copy of this, and you'll be able to keep this. Okay, so the controller is the city's chief fiscal officer, chief financial officer. The entire role is to be a check and balance on both the council and the mayor when it comes to the financial health of the city. So that power is derived from a combination of things, from the city charter, from our administrative code, and then we also have rules here in the city. There are additional powers that are conferred by state law, and it comes from, I mean, it's really what we should call it a mosaic of laws where the controller's powers are derived, and it's because it's such an old institution. What has happened over time, it's almost kind of like a Frankenstein type thing where they don't know, for example, that we used to have a board of estimates. When the board of estimates devolved, then some of those powers went to the controller. So the powers are kind of situated all over, and I'll go through some of the core duties and powers now. So the first one is that the controller is responsible for establishing all of the citywide methods for auditing, for payroll, for recording, accountancy, reporting, etc. And the controller is also responsible for all of the city's audits and investigations. So a core power of the controller is that the controller has the authority to audit or investigate all matters relating to or affecting the city's finances. It is a very broad term. We have actually we have a ton of case law about what that means. And it's pretty well settled that the controller, if it's something that is either related to or impacting the city fisc, the controller has the authority to conduct an investigation. Now, that investigation or audit has the power for the controller to not only request books and records, but also to compel testimony. So that is it's a pretty core duty and an important power of the office. And in terms of the compelling it, the controller's office has the authority to issue legal subpoenas. I'm going to skip this because my colleagues at the council talked a little bit about the budget, but I put the timeline in here for your benefit if you have any additional questions. Also, I know some of my colleagues are going to come to a meeting, I believe next month or later this month, to talk specifically about the budget and answer those specific questions. So another core duty of the controller is that the controller's office has to register all city contracts and agreements within 30 calendar days of receipt here. And our role is not to second guess the mayoral administration or the council or whoever is doing the procurement as to whether or not the procurement is something that we agree upon, but we are looking specifically to see if the funds are sufficient, if the appropriate process has been exhausted, the required certifications are there, and that there's no corruption or any other, we have actually prescribed terms, but it's really looking for fraud or corruption in the process of procurement. So that is our role. We then, within the 30-day period, we have to register it. If we decide not to register it, we have to return the contract back to the mayor's office or the council or whomever is trying to do the procurement. And the mayor then has the authority, if he still wants to go forward with it, he can essentially deem it registered, and we have 10 days to register the contract. And that is really just means that we have to push a button, to make sure that the money and the funds are released in order for the procurement to go forward. Some additional duties that I will not go into detail, but they're kind of interesting. This office also has the power to establish prevailing wage and also enforce wage laws on city contracts and certain tax-exempt properties. We also are responsible for approving the terms and issuing city bonds. We manage the city cash flow, trust funds, and bond proceeds. We are also the trustee, investment advisor, and custodian of all of the pension fund and retirement assets. This is kind of unique to the city of New York. In most jurisdictions, this lies with the state and not with the city, but this is another part of our role. And I'm telling you all this because we have lawyers that help do all of this work. So let's talk about claims. So I'm going to go through this and then I'm going to open it up so you can ask me any questions. So the charter is very clear that the comptroller is the only one who is authorized to settle and adjust claims in favor or against the city. So that means both affirmative claims, meaning when the city is saying that maybe we're going after someone and we can recover, but also claims against the city. The way it works is for many claims, not most claims, some claims don't fall within this, but most claims there's a requirement that a notice of claim has to be filed within the statutory timeframe. It's generally 90 days with some exceptions. Once that notice of claim is filed, then the comptroller's office, basically the ball is in our court. We review the claim. We often will take testimony, which is pursuant to state law. That's the General Municipal Law 50H. And then we will request documents. If we can settle the claim, then we will settle the claim. We also request documents from the agencies or whomever else. Let's say it's a police action, we'll ask the police, the NYPD, for a copy of all of their documents, if they have body cam footage, whatever they have, in order to review and analyze the claim and determine whether or not a settlement is appropriate. If the comptroller's office does not settle the claim, or if in the course of reviewing the claim, the party then decides to file in court, file a lawsuit, then it leaves our jurisdiction. Just want to point out, we pay out about 1.9 billion in claims. We've for the last 2 fiscal years, 2024 and 2025. Before that, it was about 1.5 billion. The uptick is because we have recently settled some significant class actions that have been pending for 10 plus years. So this is the key piece about the city attorney. Okay, so the charter makes it very, very clear. It's very explicit that the corporation counsel is the attorney and counsel for the city and every single agency, and has charge and conduct of all the law and business of the city and the agencies. So what that means is that the corporation counsel is the only entity that has the authority to make any legal decisions on behalf of the city. So what does that look like in practice? Most agencies, both non-mayoral and mayoral, so my office is a non-mayoral, right? Because I do not work at the pleasure of the mayor. I work for a separate independent elected. We all have delegations from the corporation counsel. So you heard my colleagues from the New York City Council talk about their Office of General Counsel. Well, their General Counsel also has a delegation from the Corporation Counsel. Every single agency that has a General Counsel or has some sort of legal function has a delegation. That delegation has limitations that allows us to do the work of the office, but some things are explicitly excluded. And one of those things that's excluded is we cannot contract for outside legal services. We can't procure, other lawyers. We cannot sign off, for example, on an amicus brief without the corporation counsel's approval. These are things that only can be done by the corporation counsel and their respective agencies. Now, the question was raised previously, and I actually have a note here. The district attorneys are not a part of the corporation counsel. Instead, they derive their authority from the state. However, if there is a claim against the city, let's say it's a malicious prosecution claim against the city that names the DA's office, then it is within the purview of the comptroller's office before it goes into litigation, and then it's in the purview of the corporation counsel once it goes into litigation. The DA's office is not They are not the ones who are recommending the settlement amount and or signing off on settlement amounts as it pertains to their own individual agencies. Now, here's where the fun part comes in. The Corporation Counsel is the only one that can handle the legal affairs for the city. However, the Comptroller has the sole authority to settle and adjust legal claims. So how does that work once a case is in controversy, once the case is in litigation? So like I said, pre-litigation, it's pretty clear. It's the Comptroller. It's completely within our purview. Once it goes into litigation, the Corporation Counsel and the lawyers that work there, and you should know, there are about 750 attorneys and about 600 support staff. So it's a very, very large, very, very, very large agency. They direct the strategy. Okay, do we answer? Do we file a motion to dismiss? Who are we gonna call for a deposition? What discovery we are requesting? They are responsible for all of those things. However, and that includes also the determination as to whether or not to represent or defend a city employee. They make that determination of whether or not it's in the scope of employment and whether that representation is warranted. They do those interviews and then they make the final determination. However, if it comes a point where there is a decision that they believe that the case should be settled, or the case should be settled or resolved, or let's say there's a trial and there's a judgment and they believe that we should negotiate that down because they don't want it to go through the appeals process or whatever the strategy is, they have to come back to the Comptroller's office and make a request for authority. We call it RFA for short. And that is basically where they will write up their analysis and they will request a certain amount of money, a settlement authority amount. We will review it, we do our own analysis, and then we will respond with, yes, we will give you the amount you requested, or maybe, no, we won't give you the amount you requested, we'll give you this much amount. And often there's an iterative process that goes back and forth before that decision is made. We need more information, we would like to see these records, whatever that is. So that is how, and then it goes back to the Corporation Counsel, and then at the Corporation Counsel's office, they then negotiate that with whoever the claimants are, the plaintiffs or the matter, or the defendants if it's an affirmative case, and then they will wrap that up. The last piece I just want to put on your radar is when it comes to indemnifying employees, that kind of falls in both litigation and the adjusting and settling. So indemnify basically says if an employee is named individually in a suit and okay, we're very clear on the lines of demarcation about the city, but what about individual employees? Well, yes, we're going to represent them, but that doesn't necessarily mean we're going to pay if they're found to be liable, right? So that's a different analysis that happens. And that's a conversation and joint determination that's made with both the Corporation Counsel and the Comptroller's office. And often that will happen. Usually that determination is made prior to trial and definitely prior to settlement. So that is my high level, and I wanted to now open it up. If you have any questions, I can talk to you about what happens when there's conflict. We've had a lot of that. So some of my claim to fame is I've sued mayoral administrations now twice on behalf of the Comptroller. And like, how do you do that when the Corp Counsel has that? I'm happy to answer any questions you have there.
You are reading my mind. I got a couple of questions then. Since Corporation Counsel represents every agency, what then happens if there's a conflict between different agencies?
Okay, so that often happens, and when there's a conflict, there are a few things that happens. So the first thing is that the Corporation Counsel will have to decide whether or not they can create essentially a wall where two different parts of the office can represent both sides of the V. But if it's truly if it's just a conflict where we're disagreeing, it's one thing. But if it's in litigation, that is very unlikely to happen. So what will happen is that we will get a waiver from the law department that says that we can retain our own counsel. We can either represent our agency as the general counsel, or we can retain our own counsel. Or the third option is we actually have a panel. The law department has a panel. They have a bench of attorneys who all they are conflict counsel. when you have two agencies that have conflicts, and then it's a bench of folks that you can already reach out to, the procurement is already done, and then you can use them. So we had a case like that, so we had to determine, like I said, we do wage enforcement and determine wages. We had to figure out the wages for ferry workers, and it was a very difficult and contentious matter. And we were opposed to the mayor's office of labor relations, and the ferry workers end up suing. And they sued both the comptroller's office and the office of labor relations. But because we had different positions, the corporation counsel represented the office of labor relations, and then I got outside conflict counsel to represent the comptroller's office.
And as a follow-up, so are there any conflicts about giving advice to your different clients? So my question is specifically pertaining to, your office is advising an agency one thing, but such advice might interact with another agency or another entity in the city. How do you deal with conflicts that might arise in that way? So pre-litigation in terms of like legal advice, is that handled then by general counsels, or is it drops directly to do that?
So even though we handle the settlement and claims, because it's so ingrained in both the charter, but just in the way we do things, everyone takes the position that the corporation counsel is the only one that can give legal advice. So even when constituents are coming to us and there's like, what's the legal advice? We refer them back there. That doesn't mean we don't have our own opinions. But it's kind of like we'll work it out internally amongst ourselves if we disagree, but we're not going as we're one city. It's like one big dysfunctional family. You have to constantly think like that when you're a city lawyer, right? Who is my client? And if you're a non-mayoral, it's easy to think, well, my client is the comptroller in the comptroller's office, but my client is also the city of New York. So I'm constantly thinking I both represent the city of New York and also the office. And when there's a tension there, you have to figure out whether it's a true conflict. So I'll give you an example of a true conflict. A true conflict was during COVID. The mayor decided that he was going to basically activate his emergency powers and get rid of all of the procurement rules during COVID, right? And in the beginning, that made sense, but 2-3 years in, okay, you can't keep doing an end run around the procurement rules, right? So there was a true conflict there. And in that conflict, we knew, okay, we're gonna have to sue the mayor and sue the city. So we then wrote to the Corp Counsel and we said, hey, we have a true conflict. And guess what? The Corp Counsel wrote back and says, absolutely, you do. Go ahead and get your own counsel. I mean, it's a crazy system because the Corp Counsel has to give you permission to sue the mayor, and actually essentially sue them, but it has worked. I have not seen it not work yet. You heard earlier, the city council, once every couple of years also sues the mayor's office, and it works.
Thank you. I'll turn it over to my other commissioners now. Commissioner Fuentes, would you like to start?
Yeah, just to go back to the wage theft piece. So in terms of enforcing that, how can you expand on the authority functions in practice and how to initiate investigations? Is that independent, or do you all rely on a different agency for that?
So again, remember I told you we get our powers from all over the place. I'll go back a little bit, but that power is actually derived from state laws. So we receive that from the state, where we get to set the prevailing wage rate for public construction buildings and building service contracts, and then we can enforce them. So we actually have, so my office is actually considered a smaller office. We have about 700 employees, and we have in all, I want to say under legal, we have about 150 people, some of which are in what we call our Bureau of Labor Law. They do that work. So we have investigators, we have attorneys. So the investigators go out, they get the complaints, and then we have attorneys who do that work. They actually appear before our Office of Administrative Hearings and Trials. So it's not it doesn't start in court. It's like hearing first. We negotiate, and then if we need to, we go to court. So yes, that is a whole group of people who do that enforcement work, and I'm happy to put you in contact because it's very, very detailed. It's a very nitty gritty, but happy to explain, make that connection for you. And just so you know, the claims piece, it's like a small insurance company, right? It feels like we run a small insurance company. We have claims examiners, we have attorneys, we have people who are, as it's coming in, we have a big fleet. So in New York, we have no fault law. So we have a ton of motor vehicle claims that come in. And these people, all they do is they review these claims and then they work with attorneys then to negotiate if it comes to that.
Just as a quick follow-up, do you feel that it's been effective in actually decreasing wage theft within the city,
It has what been effective?
this process?
You know, that effective is an interesting word. I think that there are, as with anything, there are ways for places for improvement and places where I think it works. I think having a checks and balance so that the mayor doesn't have a blank checkbook when it comes to the city's finances through whoever the city attorney is really, really, really important. But I also know, and it's something that I think about and something we're looking at is how can we leverage technology to make it more effective, not only, you know, to get the work done better, but to actually make people whole, right? You have someone who they drive over a pothole and their car is completely damaged. They can't get to work. They can't take their kids to school. And it's a very long bureaucratic process because we have so many checks and balances. So we're trying to think about how do we grapple with that.
Thank you.
You're welcome.
Great, and then I'll turn it over to Commissioner Matt Travis.
Yeah, just a quick question, more for clarification, going back to the comptroller's auditing role, you mentioned and kind of floated what's in the charter right now regarding, the comptroller has the ability to audit, all matters related to or affecting the city's finances. Wanted to just clarify, does that also mean auditing elected officials, and has that happened in the past? And your answer is yes.
Yes. So there are actually two separate powers. So the comptroller is required to audit every single agency once every 4 years. So once a term, because we have 4-year terms. And that includes the DA's offices and the borough president offices. So we do audit them. The most recent DA's office one was about language access, right? What do they, because these are both fiscal audits and performance audits. So the DA's one was what is the language access do they have for their forms and the different constituent services for people who go there. And all of that is public. We're very big on transparency. It's all on our website. You can go right now and you can pick an agency and you can see all of the audits and reports. The investigatory powers, though, that is discretionary. There's not a requirement that we conduct investigations, but that allows us to be able to do something outside of the audit process, because I don't know how familiar you're with audits, but there are some strict GAGIS requirements, and even non-GAGIS audits, they take a lot more time. The investigations allow you to really be able to do rapid response, but to investigate things that don't necessarily fall in the cycle. So a great example of that is we wanted to investigate New York City's hurricane responses, because we're having, obviously with climate change, we're having significant rainfall. We know what the city's plan was, but we're trying to figure out, okay, well, we had an event here about a year ago. Where's the city compared to what they said they were going to do? So that was an investigation as opposed to an audit.
Thank you.
Great, well, that will conclude this presentation. Thank you again so much for joining us all the way from New York. We really appreciate it.
All right, thank you. Take care and be well.
Thank you so much. All right, we're gonna get our next presenter promoted via Zoom, and with us. All right, that was coming online right now. Mr. City Prosecutor Doug Howard, from the city of Long Beach, my personal privilege, my hometown, is presenting again. Doug, has, I think he's in his, you're in your end of your second term as city prosecutor, or is this your first term?
Time flies, Justin. I'm actually in my 4th term.
Fourth term, it does fly for us all. So excited to have you present today to our commission. I think we got your slide. I don't know if you want to share them or if you just want to talk.
Well, I sent just a 2-page PowerPoint. You can either put it up on the screen or you can just share it with the panelists. I'm happy to verbally discuss what's in them. I think
Well, let's grab it, right? And
Is it gonna show up on the?
it will, if we share this, actually, it's probably easier, just walk it through it, then, it's already on our website. And I think we'll get more copies. Go ahead.
Sure. Well, very quickly, the first PowerPoint page was simply a quick summation of the cities and how they handle criminal prosecutions. And just to, by the way, for those of you who don't know me, I'm the elected city prosecutor in the city of Long Beach. I've been the city prosecutor now. I'm in my 4th term, but I've also been a contract city attorney. I was a partner at the law firm Alshire and Winder. So I know city attorney to a lesser extent. And in California, we have 58 elected district attorneys who have complete prosecutorial power throughout the state. And there are only some exceptions. There are only 14 cities that have their own authority to prosecute adult misdemeanors. The first slide was a listing of those 14, including the city of Los Angeles, which has an elected city attorney and only one legal department, which does both criminal prosecution of adult misdemeanors and also handles civil cases. Long Beach is the only city that has 2 separately elected departments. So I am the elected city prosecutor. Another person named Don McIntosh is the elected city attorney in Long Beach. We are entirely separated, different departments. Neither one of us has any control or oversight over the other. And I mentioned the rest of the cities. I don't know if you can see it yet or not, but most of these are cities in LA County: Burbank, Hawthorne, Hermosa Beach, Inglewood, Pasadena, Redondo Beach, Santa Monica, Torrance. Those are all cities that have the ability to prosecute their own cases. It's unusual for a city to be able to prosecute their own. LA, of course, is the largest city. And I did list, I don't know if you can see it, but I did list which cities have attorneys that are elected and which ones are appointed. Before I go to the next slide, can everybody see that slide, or do you have any questions about it?
We're not showing it on the screen, but we've got some options. I think people are looking on their computers.
We can see it on the dais, so that's all. Yep.
Great. As long as the panelists can see it for now. And of course, I'm hoping you make it available to everyone, Justin. So very, very quickly, the second page is just a list of potential pros and cons to the Long Beach model, which is a separate city attorney and city prosecutor. I want to preface everything that I say with the following. These are largely situational. These are my opinion based largely on the only separated city that exists in California, which is Long Beach. So these are not necessarily going to be pros and cons in a smaller city or in a larger city. These are only things that I've seen in my role as a city prosecutor. And I'm going to be as blunt and as open as possible to share my thoughts on this. So under what I would call a favorable reason to have separate departments, the first one is it does reduce accusations of prosecuting for civil advantage. And I'll give you just a couple examples that come up with some frequency. There could be a blighted property in the city that the city is looking to purchase and to convert to some other use or to tear down entirely. And so the city attorney is engaged in an eminent domain action to take that property, pay fair market value. But at the same time, a case is referred to the prosecutor's office to prosecute for some type of violation of the law. Someone may accuse my department of conspiring with the city attorney's department to drive the price down. And I can obviously say, I have no idea what's going on with that. I'm not involved with any type of procuring of property. And it's truthful. I have no role whatsoever. I don't know what the city attorney's office is doing. They don't know what I'm doing. So that's just one example where I think it's a benefit. Another one that comes up frequently is when there is civil litigation. An example could be a police officer is accused of doing something wrong. I may be prosecuting the case, that exact same incident, and someone might be accusing me of prosecuting that case in order to try to defend the city from some type of civil liability. I don't have any role in civil liability. It's not my job. I know nothing about the civil case, and I can tell them that. So that the first thing that I mentioned is it definitely reduces the appearance of or the accusation of prosecuting for civil advantage. And a smaller city, obviously, that's going to be a much larger problem than a large city like Los Angeles, where you really do have separate and distinct departments. The second thing is it allows me to focus on prosecutions. I'm the elected head of the office. I dictate the prosecutorial policies within the office. I don't have to worry about what is happening when it comes to legal advice to departments or attending city council meetings to give advice to the city council. I don't give legal advice to the city council. That's the city attorney's job. I'm going to focus on criminal prosecutions. The third bullet I put on here is I can also focus on alternatives to prosecution. I don't know if you've studied this at all, but prosecutorial discretion is extremely powerful, and it gives prosecutors the ability to not prosecute, to allow alternatives such as pre-filing diversion, deferred entry of judgment, other types of basically settlements of cases that result in people being treated differently from the traditional criminal justice system. Our office, for example, created the first, that I know of, the first jobs-based diversion program in the country. We were the first to launch law enforcement assisted diversion, which is a police and prosecutor pre-booking diversion program. And those are things that happened, I think, largely because we have the ability to focus in that area. The third thing is clearly there's an independence from the legislative branch. I am not the advisor to the legislative branch, and there is no appearance that I am. So I have no role. I don't even go to city council meetings. So I'm not involved in any way with the legislative branch. And the public may be concerned that I'm doing something on behalf of some council member. Well, I really don't have any role with council members. So separation allows that role to be separated from the person who's actually giving the legal advice to the city council. A couple quick cons. These are things that I think are pretty obvious. There's going to be a possible redundancy in costs and efficiency. I think it can be inefficient to have two separate offices. Obviously, I have staff. Well, you have two elected heads of office for one. So you have two people that are each elected that are separate, and that creates an inefficiency rather than having one office with one chief of staff, one payroll analyst, or fewer staff. Second, there's also the obvious opportunity for a lack of legal coordination. I may be telling the police department, these are the elements of a crime. You must have these elements to present a case to us in court, or present a case to us that we can file in court. The city attorney's office is going to be thinking about civil liability. They may be given or giving legal advice that is to an officer that is along the lines of reducing civil liability. I'm focused on the elements of a case. They may be focused on civil liability. So having one department would potentially allow you to eliminate that duplication and assist in legal coordination. And then finally, there could be adverse legal opinions given by the city attorney and the city prosecutor. I'll give you a very quick example. Before I was elected, when medical marijuana dispensaries were brand new and the state law was changing quickly, there was a disagreement. The city attorney had an opinion about what the city could do to license operators who would then open medical marijuana dispensaries. And the city prosecutor at the time said, you cannot license medical marijuana dispensaries because marijuana is illegal under federal law. And so you had two very conflicting opinions on the very same thing, one given by the city prosecutor and the other by the city attorney. And that can happen when you have separate departments as well. So I've given you a very quick summation, and I did that intentionally because I wanted to give you plenty of time to ask questions about the Long Beach model or about any of the other models that you are considering.
Great, thank you. I'll let one of my fellow commissioners start the question. Would you like to go first, Commissioner Foyt?
Perfect. What mechanisms would you say exist to ensure accountability for your office's decisions while preserving prosecutorial independence?
I missed the first part of that question. Could you please repeat it?
Yeah, what mechanisms exist to ensure accountability for your office?
Oh, mechanisms for accountability. Well, we are separate from the council. So if you mean accountability as far as keeping track of trainings and making sure that attorneys are qualified when they're hired, if you mean that sort of thing, our departments are separate. So their hiring process is going to be separate from my hiring process. They might get a great candidate for, that would be a great prosecutor, but I won't know about it because it's an entirely separate recruitment process. But we're both accountable to the voters. The city prosecutor and the city attorney are each accountable to the voters. So if the voters think I'm doing something wrong, of course, every election cycle, they have an option to hire another city prosecutor. Long Beach is the only city I know of, by the way, that has a separate position that is an elected city prosecutor, at least in California.
This is Commissioner Ray. Thank you for joining us today. I mean, I didn't realize Long Beach had a separation in the city attorney and prosecutor, so this is really just learn and hear from you. I had just wanted to pick your brain a little and ask for your personal thoughts on, you listed out a couple of cons. Was wondering if we can share if there's anything that you think can be supplemented to alleviate and combat some of these cons, so like some of the inefficiencies that you mentioned. And
Yeah, as far as my personal opinion goes, I think you have to be careful crafting a system if it's based on personalities or based on situations. You could have, two cities could have the exact same structure of government, but have entirely different cultures and therefore have entirely different outcomes. I mentioned that there was a time in which my predecessor, city prosecutor, disagreed with the city attorney, and so the two of them disagreed. Well, that's a cultural thing. I happen to get along very well with the current city attorney. If I had a difference of opinion, I would certainly share it with the city attorney privately before I shared it publicly. That's a situational thing. So I would say, this is your constitution. This is a very important decision, whatever you change in your city charter, and whether it's regarding legal services or some other service. I would be careful and make sure that you're not making any changes based on, for example, who is in the positions of prosecutor or attorney. And in Long Beach, it's worked out well, but that's because we have a particular culture where the electeds, we aren't political. I don't think, though I'm elected, most people in Long Beach probably don't think of me as an elected official or think of the city attorney as an elected official. They think of us as professional attorneys who focus on our two areas.
Thank you.
Thank you. In Long Beach, who is the city's defense lawyer and who prosecutes the city on behalf of the people?
So in the city of Long Beach, I prosecute all criminal cases. And when I go to court, I say on behalf of the state of California, just like the district attorney does. Your city attorney's office also goes to court and they present cases on behalf of the people of the state of California. And that's because both of our offices are kind of carved out of the district attorney. So in LA County, there is only one elected district attorney. But as I mentioned, and as you see on the first slide, there are 10 different cities that prosecute their own adult misdemeanors. So in LA County, the district attorney has jurisdiction over all felonies, regardless of the city, and they have jurisdiction over all juvenile cases, regardless of the city. But in those 10 cities, the cities themselves prosecute adult misdemeanor cases, whether it's a state law violation or whether it's a city law violation. So just to give you some examples of state law misdemeanors, DUI, domestic violence, even vehicular manslaughter, vandalism, petty theft. These are typical misdemeanor crimes under the state of California law. In the city of Lakewood, the district attorney will prosecute misdemeanors, but in Long Beach, the city of Long Beach would prosecute it, but we're both bringing the action on behalf of the people of the state of California because it's a criminal prosecution.
I'm thinking of a situation in LA at least where the city attorney defends the city and it prosecutes on behalf of the people of the state of California. In particular, like when giving advice to LAPD, there could be potential conflicts in that case. So I guess for Long Beach in particular, because you have separate city prosecutor and city attorney, does that mean that when the city is sued, like when LAPD is sued, you're not the defense, it's the city attorney who would be the defense in that case or their office?
That's correct. In Long Beach, the Long Beach City Attorney would represent the Long Beach Police Department in a civil action. I may be prosecuting a case that arises out of the exact same exchange. My case is entirely separate. Mine's a criminal case against a defendant. Separately, the city attorney would handle something that might be a civil case against the city. And that does happen.
Yeah, so in the city of LA, since those two roles are housed within the same, office, do you see any potential, and in your personal opinion, obviously, do you see any potential conflicts that could arise?
I don't know enough about the structure of your city attorney's office. If you remember the last speaker, who, by the way, I thought was fascinating, Justine Rivera, I think was her name. She talked about how they separate the office, and that's called a firewall in the legal community. They put a firewall up between an attorney who's handling one matter and an attorney who's handling another matter. So in just to give you, in the city of LA, you have such a big law department. They may be able to create a firewall that separates the attorneys handling the civil defense from the attorneys who are handling the criminal prosecution. If you have the city attorney's input probably for LA, that'd probably be more valuable than my input. I would just be speculating because I've never worked in that office.
No, that's helpful. And then you said that since the roles are separate in Long Beach, that the advice that you give to a department like LAPD would be vastly different from the advice the city attorney gives, because what the incentives of your office are different.
Yeah, and I don't give advice to the police department on how to do their job or how to avoid civil liability. The advice that I give would be, here are the elements of the crime. Here's the case law that discusses those elements. Being a police officer, you're almost an attorney on your own. And so they need to be updated on the current law if things change, if statutes change. So we're not really giving them legal advice. We're telling them what can and cannot be prosecuted. So it's a little bit different.
Yeah, and then sometimes that advice could then be at odds with what the city attorney gives with regard to civil issues.
It could be, sure.
Okay, well, those are all my questions. Do any of the commissioner other questions? Well, thank you so much for your time. We appreciate you joining us, especially, in a different time zone today.
Not a problem. And if you have any follow-up questions, don't hesitate to reach out. Thanks, Justin. Take care.
Thank you so much, man.
Bye-bye.
Perfect. All right, let us get it set up. Hold on, give us a second. Hold on. Okay, and then we are gonna do this. So
Thank you so much for joining us, City Attorney. We appreciate it.
all right.
It's my pleasure, we miss it for the world.
Well, we are ready whenever you are, so feel free to start.
Well, good afternoon, commissioners and executive director, it's my pleasure to be here. I am here today, and I'm happy to answer any questions that you like on any topic, but I'm specifically focused on the importance of having a single unified office that is represented by an elected city attorney. I assume that you all received a copy of the letter that we submitted. And I think the letter speaks for itself, although for the benefit of the public or anybody else, I'm happy to go through some of the issues. I'd like to start by saying that in my opinion, and that's just my opinion, anytime you have 3 lawyers in a room, you're gonna wind up with 4 opinions. Okay, at least 4, because you're gonna have one for each lawyer. You're gonna have the ones that any 2 of them can agree upon, and you're gonna have the one that's unanimous, if there is a unanimous one. In my experience, when you have an entity, whether it is a municipal corporation, of any other kind of public entity, or even a private corporation, you typically need to get into a who decides. Okay, those disputes rarely, if ever, find their way into public view. There's good and valid reasons for that. If we're going to give separate standing to a legal entity, the capacity to sue or be sued, the capacity to speak with one voice, you need a person whose determination as to what the position of the entity is valid and final. In this city, we have elected to make that the elected city attorney. Only the elected city attorney ultimately has the responsibility to report back to the voters. Only the elected city attorney can be replaced by a popular vote. If you have an appointed city attorney, the concern is obviously, is it one? And can one city attorney serve many masters any better than an elected city attorney? If the response is you have many, the problem becomes, okay, what happens? I did listen to a part of the New York presentation. I sort of shut it off after a little while because there were too many lawyers and too many law departments for me to keep track. And I think I heard the clip where someone said, oh yeah, the city council sues the mayor every 2 weeks or vice versa, or every 2 years. That is not a scenario that I think I would like to see in Los Angeles. We have a proud tradition of about 176 years of coming together. I like to describe who is my client, okay, with limited exceptions, to the city council in 2 ways. One is for the purposes of giving advice. The client is the person requesting it, and that person controls the privilege. That is necessary in order to encourage each individual in each department to be forthcoming and to come forward with the tough questions that we can then help advise on. There is an old decision from, I think it was the State Bar of California, reprimanding a then elected city attorney for taking a confidential communication with the client and reporting it as corruption. I actually think that's healthy. I think that the elected city attorney cannot so-called out the client in the public. But I do reserve the right, and I do so with everybody that my office speaks to say, ultimately, we represent the city. We don't represent you individually. So we're happy to give you advice. We will not run around volunteering information that you communicate with us absent a crime or a fraud that's going to be committed as opposed to something in the past. But we respond to what I call the rule of 8. The rule of 8 is that the ultimate client for the city of Los Angeles is anything that 8 members of the city council plus the mayor can agree upon, or anything that 10 or more members of the city council agree upon overriding the mayor. That's who controls privilege for purposes of waiver. So before my office waives privilege in any way, shape, or form, that is a prerogative that belongs to the city council. My office controls something called work product privilege. As long as what we are working on is our thought process, our analysis, we enjoy the same privilege that any lawyer in private practice does, so that we are free to do drafts, we are free to communicate advice, we are free to do it internally, so that the work product is the best possible. I don't know how either of those privileges would work if you have separate law offices representing each department, representing each individual. I see it not only as a problem from the standpoint of intra-city, interdepartmental disputes, but also as a problem from the standpoint of the rules of professional responsibility and the ability to maintain the internal candor and within the context of the privilege that I think is required to result in great governance, or at least the best governance possible under the circumstances. I want to address one thing. I had said in an informal interview that I believed that making my office appointed was a poison pill. I don't really like things taken out of context, and as I think most people will tell you, someone who's perfectly willing to talk about controversial subjects. What I meant by that, and I want to be clear, is that I do not believe that the voters of the city of Los Angeles are going to think that their elected official knows better than they do. At the end of the day, anyone who is an informed voter understands the way the city works and understands that they, the voters, can replace the city attorney. And so a charter commission that is tied to a proposal that takes away power from the voters necessarily weakens the likelihood of its passage amongst the more informed part of the voting population. And again, as I prefaced my remarks, these are all my opinion. For a moment on speaking on the split prosecutorial versus city attorney role. And it's very interesting. I made a lot of changes in my office, to be clear, especially in connection with the criminal branch. Because when I took office, the office had a long history that dated back to the time before the rules of professional conduct had been amended several times. And was passed in, I think, the late 70s by then city attorney Bert Hines, which basically said, until we figure out what some of these cases mean, we're going to cut off communication between the criminal side and the civil side. We're going to build this so-called ethical wall. And there shall the two meet. Except that if anybody has any issues or any disputes, they come up to me, this elected city attorney, and I get to decide. So when I read that memo, it was like, yes, there really is no wall. The arguments that were made in favor of this so-called ethical wall, and I'm not saying there isn't an ethical wall for some purposes, but there's absolutely no communication. One of the arguments that was made was, well, if we get questions that would require us to disclose information to a defendant under Brady or Giglio on the criminal side, that's a problem if we don't have a wall, because we would need to disclose. And my response to that was, of course we do. I am one person, I can't separate my brain. If I have information on the left side that needs to be disclosed on the criminal side, it will be disclosed. You have three options if it's protected by privilege. One, we can get a waiver of the privilege, and we can go ask. We have a legal obligation on the criminal side to disclose. Will the client, for purposes of this privilege, agree to waive? Two, we can recuse. We have information that we can't disclose, we recuse, we send it to the district attorney, period. Or three, we can dismiss the prosecution. Because after all, we only prosecute misdemeanors. There are some very serious misdemeanors. But if there is Brady or Giglio information that must be disclosed, that we cannot disclose due to attorney-client privilege, then we cannot be the prosecutor. I am the chief prosecutor for the city of Los Angeles. I can't divorce myself from that responsibility and that role. And therefore, I must disclose, recuse, or dismiss. Those are the only three options. The independence that I think a city attorney such as me brings to this process is critically important. I think you can speak to any of my clients. I try to stay in the lane of city attorney. I do not become the 16th member of city council. I'm not a policymaker. I try to call the balls and strikes across the plate as fairly as I see them. And I am as responsive to each member of city council as I am to the others, and to the mayor and to the controller. I have the pleasure of representing 17 other elected officials, and that is not always easy. But to say that it depoliticizes the office to make it appointed is a farce. Because it takes an elected official to have the independence and the backbone to give the people who control your budget and the people who are themselves elected the fair, independent advice that may not always be welcome, but that is absolutely necessary for the healthy functioning of our city. I think that to have it otherwise is to watch the city devolve into competing warfare among other electeds. I think I've addressed the direct accountability to the voters and the fact that we are one city. And as one city, we have to have one position to protect ourselves. Can you imagine how bad it would be if in connection with any given litigation, we had different departments or different parts of the city not working internally to come to a solution, but able to instruct their own, and I don't mean to use a pejorative term, but their own pet lawyer, their own advocate, to go out into court. And in effect, what our city is doing under those circumstances is ceding the elected power, the legislative power, the executive power of a sovereign to a court, to an unelected, well, in Superior Court it would be elected, but in District Court it would not be, to an unelected or at least a single judge who would get to decide these difficult issues. Legislation is often described as sausage making. It is. It's a compromise. It's people coming together and trying to find common ground. Having one city attorney who can validate the ultimate piece of legislation for form and legality, who can step in to make sure it's constitutional and doesn't violate federal, state, or local law without putting her thumb on the scale of what the result should be, I think is a critical part of how our city functions. So with that, I'm happy to take questions. Have I left time on the clock? Stefan, did you want to add?
Thank you again for joining us. My first question, and by asking this, I don't mean to impeach the ethical substance of any of our, former city attorneys, but there have been city attorneys in the past who have decided to run for mayor. And these were the same city attorneys that had to have given advice to council, given advice to other entities in the city, and there's a perception among some voters and some of the ad class that if the city attorney has to think about their exit strategy in their next elected office, but they also have to give advice to different entities across the government, the city government, that the advice that they have it could consider how it might affect their ability to succeed in an election in the future. And do you think that that mere perception is, I mean, obviously you don't think it's enough reason to bifurcate the current role, but what are your opinions about the idea that that perception even exists under the current model?
Let me start by disclaiming any personal interest in the outcome of this commission's decision. No, I'm serious. By the time this commission decides whether my office is appointed or elected, I will have been turned down even if I'm reelected. So I have no vested interest in this. Let me also disclaim any interest in running for any other office. I am currently 67 years old. If God willing, I am reelected, I will be 72 by the time I'm done, and someone once told me, "Leave while you still can, not when somebody has to carry you out." I have no desire to be the mayor or to have any other elected position in local, county, or state government or federal government. That's not what I do. Having said that, I acknowledge what you just said, but every elected office is the same. The district attorney is often charged with wanting to be the attorney general and making prosecutorial decisions for that reason. Our elected city council members often have their eye on the mayoral office or on a seat in Sacramento or in Congress. The fact that there are individuals who make a career out of politics does not necessarily politicize the office. Probably the single most important protection against that advice in my office is that I supervise an office of 1,000 dedicated, hardworking public servants. I take this opportunity to commend the people in my office for the good work that they do. I commend my office for having the best interests of the city as a whole at heart all of the time, because that's their employer. their livelihoods, their loyalties, their relationships are to the municipal corporation that is the city of Los Angeles. Not to, and again, I tend to speak colorfully sometimes, not to the bobblehead who happens to hold the elected office. Some of us are better than others for some reasons or others. But at the end of the day, what gives my 1,000 employees the ability to operate independently and give the kind of advice that they do is the fact that my position is also elected. And being a citywide elected provides cover for the difficult advice that my lawyers and my other legal professionals sometimes have to give.
Thank you, I appreciate it, it's not that that question could go unaddressed in this hearing, but my second question has to do with the idea that it's city attorney's job both to defend the city, you know, in lawsuits, but also to prosecute on behalf of the people. And there are several agencies that, and LAPD is one of the agencies that typically is on both sides of that coin, among others. Could you talk about the strategies that your office employs to prevent conflicts in that scenario?
Sure, one of the examples that I was given why we needed the ethical wall was precisely that situation. That we might learn something in a situation where the LAPD or individual officers were our clients in a 1983 action, that we would need to disclose to the individual who was also a suspect in misdemeanor. For me, that's an easy answer. As I told you, get a waiver, I recuse or I dismiss. It's just not a difficult question. I represent all kinds of departments that have both that have competing interests. And what I can tell you is that in the dialogue inside my own office, the only difference is, so when you have 3 lawyers, you have at least 4 opinions. That conversation all takes place in my office. And when we speak with one voice. One of the things that I've tried to do is before I took office in my last campaign, I pointed to the fact specifically that I had seen a CEQA opinion from the court that took exactly the opposite position of CEQA position up here for planning and land use. I've put a stop to that practice. We have practice groups, we collaborate, and we speak internally with one voice. So we vet things internally. It's not like each lawyer gets to go out and do what they want. They still occasionally do that. But let's just say it's much less than it was when I took office. And to be able to engage in the process, whether the issue is land use CEQA or the Los Angeles Police Department or the ratepayers' interests of the DWP, there's always going to be conflicts. And the one thing I can assure you, whether or not you trust me as an elected not to run for something else, I can assure you that my lawyers and my other legal professionals really are vested with the good faith and the expertise to resolve those issues internally and come up with the very best recommendation that we can. Not just for the interests of a specific department, but for the interests of the public, of the city as a whole, of the voters and the residents of the city of Los Angeles.
Thank you. That's the end of my time. I'll now cede to my other commissioner, I will serve as Commissioner Fuentes.
Thank you again for joining us today. So just carrying on, I'm gonna kind of restate Commissioner Arvedas's question in a little bit of a different context, but in previous meetings, several presenters and members of the public had raised concerns about what they see as the politicization of the city attorney's office, going into cases like the Venice Dell project, where your office was perceived as playing a policy shaping role rather than strictly serving as legal counsel. How do you respond to that characterization?
It's utterly false. And I'm trying to think of what I can say publicly. And I also have to be a little bit cautious because there are currently, I think, 5 litigation matters pending over that project. So the truth will come out, okay? We reached a point where there was a reconfiguration of the project that satisfied my legal concerns. And I thought that had been agreed to. Apparently it was not. My concerns were purely legal. Today, I think I would tell you the following. There is no Venice Down project. I mean, it was rejected by the Department of Transportation. And at this point, if you look at the latest budget, it would cost something like, I think it was $135 million, and it boils down to about $1,400,000 or $1,500,000 per unit for a 400 square foot studio. This is not about politics. And it's not even about budget, because I tend to keep my mouth shut on purely fiscal issues. Although, from just witness, I didn't weigh in on some of the most difficult fiscal issues facing the city in the last several months. But when you look at affordability, and I would leave you with this, affordability isn't just about the rent that you charge. Affordability is about what it costs to build, what it costs to acquire, what it costs to create. And when the need is as large as it is in the city of Los Angeles, we must conserve and be thrifty about our limited resources so that we can provide the maximum benefit to the maximum number of people and not get fixated on a single individual project. What I think I will say is I've never seen this much attention on any one project, and it raises my eyebrows.
Just as a follow-up, do you believe that the current city charter prevents sufficient guardrails to prevent your office from becoming entangled in political or development decisions moving forward?
I have changed a lot of the business practices in my office. Okay, I have, without going into a lot of detail, I said that I would shut down avenues to corruption when I took office. I have zero evidence of corruption anywhere in my office or in the city, okay? I want to make that clear. But I will also tell you that I didn't look. I don't care what happened in the past. I care what happens under my administration going forward. And so I have done simple things in implementing best business practices and financial practices to ensure that there are, I can never prevent someone from misbehaving badly, but at least the common sorts of practices that might be perceived or misperceived by the public as undue involvement or entanglement by my office or by other city officials in the land use process, by enforcing section 1022 of the city charter with respect to labor contracts, by enforcing the competitive bidding procedures of the city and trying to make them simpler so that you don't always have to go out on a 28-page RFP and a 9-month process for scaling. I have tried to make the process much more transparent and favorable. Whenever there is a proposal to sole source an agreement to a given developer or nonprofit entity or anybody else, whether it's by sale or a 99-year lease or an exclusive negotiating agreement, my office has held the line on legality and making sure that it's put back out to bid so that any dedication of public resources and taxpayer dollars is transparent and visible.
Thank you. Oh, sorry, not to cut you off. Yes, okay.
So part of your question.
Introduce yourself.
A little closer to the microphone, I'm sorry, I can't get any closer. It is calm, we get more this way. So part of your question was whether the charter is protected enough. Political corruption. I think the answer, and this was embedded in what.
It was political or development decision.
Most of the avenues for those problems are inherently political, but the city attorney's power is procedural, protection of law. Really, the city attorney really doesn't have the levers to do that, and I think, she's very careful, as most city attorneys are, they don't try those levers. They're not there to hold.
And that's part of the benefit of having an apolitical but elected city attorney.
Thank you. We'll end today's questioning with Commissioner Red.
Yeah, I mean, thank you for being here. I feel like you started to answer a couple of my questions. I think mainly, I wanted to ask from a procedural standpoint, if there's anywhere in the charter where you believe that there could be more clarification. I think that was one. And then secondly, there's a more general question of kind of referring back to your letter on direct accountability to the voters. Was wondering, in your role as city attorney, how do you and your role and your office, stay engaged and kind of stay accountable to the different diverse groups that are in LA? Because I know you mentioned your clients.
Stay accountable to what?
The different diverse interest groups in LA as a city as a whole.
I promise you I didn't plant that question, but thank you very much for the question. I am the first woman elected to this post. I'm also the first Latina elected to citywide office. My commitment to having my leadership, my office, and the city reflect the diversity of our communities, I think cannot seriously be questioned. If you look at my leadership team, it looks very much like the city of LA, and I'm very proud of that. If you look at the hiring that we've done, it looks very much like the city of LA. I like to joke, we got the gold seal from the State Bar for Diversity, Equity, and Inclusion in 2023. San Francisco got the silver, San Diego got the bronze, and we got the gold. My chief equity officer received recognition and award from the International Municipal Lawyers Conference this year. I have formed a community law corps. Okay, it is basically a successor to the then popular neighborhood prosecutor program. Again, I don't shy away from difficult topics. The neighborhood prosecutor program as then constructed did not work under the rules of professional responsibility as amended in 2018 and 2021. I don't want to get in the weeds and bore you, but I came to the conclusion that it did not work under the new rules that govern our standards. So what I did was I separated the functions. The prosecution aspect of it stayed in the criminal branch. My prosecutors need to be independent. The community serving aspect of it was moved out to the municipal branch, and I formed the community law corps, which is in essence the successor to the neighborhood prosecutor program, only in the municipal branch. The community law corps has resolved over 3,000 complaints in the first 18 months of existence. I also was the first city attorney to form a workers' rights division in my office. And that workers' rights division has 6 dedicated lawyers and some support staff. I was the first city attorney to hire a tenant activist who works exclusively on tenant issues in a city that is represented 70% by tenants. At the same time, I regularly meet with our business community and our small businesses to see what we can do to get some of the red tape and the difficulties of doing business in Los Angeles simplified for them. My office, specifically my executive suite, has Senior Citizens Day, Senior Centers Day all over the city. And we reach out to our elderly community to see what we can do to help them. If you go to just about any community event of any size, we will have at least a pop-up tent with information there. We not only drafted some of the just cause ordinance language in record time for city council when they asked for it. We printed pamphlets in 6 languages, and we distributed those across the city, literally tens of thousands of pamphlets, with the assistance of a number of activist tenant organizations. I can keep going. We reach out, we have a city help desk, we have an emergency hotline. Our commitment to our constituents is we will return a phone call or an email within 48 hours with a name attached to be able to follow up on whatever the issue is. We keep databases internally and we can't possibly cover all of the matters as quickly as everybody would like. But I am here, I am available, I have an open door policy. I do, or I have done lunches once or twice a month with different interest groups. And different parts of the city and different communities to make sure that I don't lose touch with what is important on a daily basis to our residents.
Thank you again for joining us today. We really appreciate you that you took the time to come to our committee. Thank you.
Thank you for the opportunity and not just for making my office kind of appointed. I appreciate that. I do want to follow up on one thing that I forgot. We do have a number of specific suggestions for the charter. I did not view today's forum as being the appropriate forum for that. I thought the topic was my office, but we're more than happy to submit a supplemental letter for your consideration.
Thank you. Please do so, and our staff will be at dinner.
Thank you.
Thank you so much. So that does conclude, item number 1. For we do public comment on this, we can get a motion to receive.
So moved.
Second.
Great. Well, received and filed. Fantastic. Great. So now we will move on to public comment. We'll go our executive director to administer public comment.
Perfect, we're on the list right now. Thank you, Mr. Chair. So much. All right, we have these 2 names signed up, so I'm just gonna call you out both, Rob and Nicholas. We have a short list, so 3 up to 3 minutes. How much would you like?
Whatever the max is.
3 minutes. Okay,
Can you,
well,
I don't have a phone. Can you say no in that 30 seconds?
sure, well, there's 30 seconds left and go.
So on the topic of the city attorney, I did want to just kind of note one thing regarding the city attorney's letter. She repeatedly highlighted, former chair Chemerinsky's, position on the matter. And I think that, listening to that meeting we had with him in September is super, super clear. This is somebody that has an amazing recollection of what happened back then. But I do think it's important to also acknowledge he has moved on. And has not necessarily been steeped in the city of LA's politics in the last decade or so. And there was a point in that conversation where he uplifted redistricting reform and the need for y'all to look at that. The need to look at ethics reform, giving them a protected budget. We voted on that stuff last year. So I think we need to acknowledge that. City attorney used the word objective a lot and noted the client is the city, not the politicians. And I think that's just a bunch of idealistic gobbledygook. They'll never admit it because they can't. But there is a pecking order here. You see that, there's a difference between how, if there's a 50 ball, 60-40, they're probably gonna err on the side of the council of the mayor is supposed to do. Like, there is internal politics within that office, and that is just a reality. They're relying for their budget on the mayor and the council. They're at the top. So let's not pretend that it's the client. There are many times where there's things that the city attorney sees that are problematic, but will sit there and say nothing about, even though they are infringing upon the law as it comes to the public. They also pointed to a budget forecast from 100 years ago. I haven't looked at that study and whatever that was 100 years ago. So I just think it's, maybe it would cost us more money, I don't wanna dismiss that, but pointing to a study from 100 years ago is a bit much. It's also a bit much to, point to a previous bifurcation of the office when it was actually reverse what we're looking at. Nobody here is proposing we go back to what they had 100 years ago for a good reason. I don't know why they ever did that. This idea that the city attorney is independent, they go through the campaign process.
30 seconds.
Let's not pretend that they don't. Let's not pretend that they're not reliant on LAPPL money, apartment association money. Let's talk about ethics. The fact that we have it enshrined in our charter, a 2-tier justice system, where the city attorney does not go after criminality with our elected officials, as far as what happens here. What they do for other people is what they do outside of do. Venice Dell, I don't know if you paid attention to that answer. That wasn't a legal answer. That was a policy answer.
Thank you so much.
So that wasn't a policy answer. That tells you everything you need to know.
Thank you, and reset. How long?
3 minutes.
There you go.
I'd like to echo the sentiment of Rob, and it's inherently a position that is vulnerable to politics if it's elected, and it also has its financing coming from public elected officials. But I'm getting my good afternoon, commissioners, and thank you for the opportunity to speak. Los Angeles deserves the city's attorney's office that's powerful enough to protect the public interest, independent enough to resist political pressure, and transparent enough for every entity to understand. But right now, the public often doesn't know what the city attorney actually does. And that lack of clarity makes accountability harder, not easier. We can fix this by pairing independence with transparency. Like New York City's Corporation Counsel and Comptroller, LA should grant its city attorney clear authority to issue public legal opinions, audit contracts for corruption, and use subpoena power when necessary to compel records and testimony. These powers may go off some genuine check and corruption ways, not just a passive legal advice. Just as importantly, all should be required to publish plain language annual reports explaining what cases were prosecuted, what settlements were reached, and what legal guidance was found and issued to city departments. When residents can see and understand what the city attorney is doing, the office becomes not just powerful, but trusted, which is critical for anything that happens in this building. We need trust. I also want to urge the commission to look seriously at a hybrid model like presented by Councilmember Tony Coster that keeps an elected city attorney while creating an appointed city prosecutor, a concept supported by him and model effectively in Long Beach. Under the structure, the elected city attorney would focus on civil law, contracts, and defending the city, while an appointed prosecutor would handle misdemeanors, diversion programs, and community-based justice. This division reduces conflicts of interest, prevents one office from advising policymakers while also prosecuting residents under those same policies, and allows for true specialization. The prosecutors could be selected to a merit-based commission confirmed by council, ensuring both professionalism and independence. Annual joint reporting would ensure coordination without duplication. These reforms, stronger oversight powers, plain language transparency, and a dual office model would together make Los Angeles legal system more ethical, efficient, and understandable. And our city attorney should not be a political figurehead or a bureaucratic black box, or one where it says one thing but de facto does another, or even has the ability to do another. The way you combat corruption and gain trust is not just to hope someone does better or just to take their word, no matter how good of a person they are, but you create a structure where you disincentivize corruption. 30 seconds. Regardless, the city attorney should be a guardian of the public trust, when it just clearly to the people it serves. And it is inextricably linked to the financial health, the trust of our city, and it's one of the offices that we know the least about. So making it simpler, plain language, and structuring as a hybrid model, we would massively benefit us all.
Thank you so much. And just one last time, is there anyone else who would like to give a public comment before we conclude? Seeing none, thank you, that concludes our comments.
Thank you. Also left on our agenda overhang is neighborhood council comment. Are there any neighborhood councils here with approved community impact statements? Seeing none, we can move on to adjourning today's meeting. Do I have a motion to adjourn?
So moved.
Seeing none. Okay, great. Well, today's meeting is adjourned. Thank you so much, everybody.
Yes, and the comment, our next, I think, infrastructure, committee will, we're looking for the members on that. Thank you so much.